Hi there, and welcome to the PSRB LAWCAST. I'm your host, Adam Wright. Each episode features dynamic conversations with attorneys from the law firm of Pellegrini, Seeley, Ryan, and Blakesley in Massachusetts, and we discuss a wide range of topics relevant to personal injury law. We try to bring you information about the various aspects of personal injury law and the legal process. And we understand that approaching a law firm to help you can often be intimidating, which is why this podcast is designed to make personal injury law easier to understand and to help you navigate the processes with greater comfort. Remember, every case is different, and in order for us to provide you with accurate information and advice relevant to your specific circumstance, it's important to set up an appointment with one of our attorneys to meet in person. Today, we are joined by attorney Ron Kidd. Ron's impassioned advocacy for injured people has led to many awards and recognitions, including being named Lawyer of the Year by Massachusetts Lawyers Weekly. Ron concentrates his practice in the area of workers' compensation, professional malpractice law, and personal injury law, and he is known for his activism on defibrillator-related issues. In addition to being an attorney, Mr. Kidd also is an experienced and skilled mediator and has spent a lot of time working with parties in a variety of cases to try to help them come to a equitable resolution of their case. So he's a perfect person to talk about alternative dispute resolution. Hi, Ron Kidd.
Good afternoon.
So glad you could be here. You know, today we're going to talk about some forms of what's known as alternative dispute resolution. And most people, when they're in need of recovering money from someone whose actions have caused them injury, whether financial or physical, think about a lawsuit, right? I mean, we've all watched the inside of a courtroom on TV, and we'd assume that's where our case is going to be decided. That would be the forum for pursuing a case. But there's other ways to resolve a case other than trial, and that's what we're going to talk about today. So tell us a little bit about some of the other alternative dispute resolution options rather than going to trial, and why would someone want to take advantage of one of those other options?
Well, I think first I might say that this is one of the biggest changes in the practice of law from the time when I first began practicing quite a long period ago. But there are really three kind of alternatives to going to trial. One is if the parties are able to achieve their own resolution by negotiating between themselves. The two more common ways of trying to achieve resolution now are mediation and arbitration, and it's important to distinguish between the two. An arbitration is typically a binding situation in which the parties agree to send their dispute to an arbitrator who will, in fact, decide that dispute. And typically, the agreements to go to arbitration preclude any kind of appeal or anything beyond the arbitration itself. So you really simply submit the matter, typically with evidence, but it's up to the arbitrator, and the arbitrator decides the fate of the parties.
And who is the arbitrator? Is it a judge, or is it a professional arbitrator? How does that work?
Well, typically, it can almost be anybody, but typically it's usually a lawyer, though some ex-judges, retired judges will act as arbitrators. And on a rare occasion, it might even go to a layperson if it were like a specialty area, for example, scientific area or something that which called for specialized knowledge. So it could even be a layperson, but typically it's either a lawyer or a retired judge.
Now, with an arbitrator, that person has the ability to decide the case. To get to an arbitrator, is that something the two parties have to agree to do?
Absolutely. This would have to be, and it could be multiple parties. We'll probably always talk today in a two-party situation, but oftentimes disputes involving multiple parties, where there may be more than one defendant or third-party defendants. Those kinds of cases often the kinds of cases that will go to an arbitrator.
And the arbitrator is selected by all the parties concerned.
Everyone has to agree.
And then I'm assuming someone has to pay for the arbitrator.
Typically, the fees for the arbitrator are split among the parties.
Okay. And I would think, and we'll talk more about this in a bit, but I would think overall this could be a much more or much less adversarial process potentially, and probably a lot less expensive than going to court.
Yeah, I was going to say it may be just as adversarial depending on who the parties are and who their lawyers are, but it certainly lends itself to less expense. And the earlier in the process, the litigation process, that you can agree to these things, the less costly it becomes for everybody.
Yeah, I know that if we watch, the average person watches on TV or a movie, and they look at a courtroom situation, and of course there's testimony. Does that happen in front of an arbitrator? Is there testimony, or just the facts are presented and the arbitrator makes a decision?
Again, it very much depends on what the parties agree to. In some instances, it can be just as vigorous as a trial. In most situations, however, it's a more relaxed atmosphere in the sense that the rules of evidence may not necessarily apply. And, people, I think, get a little more freedom in what they're able to present to the arbitrator, whether that's good or bad.
Right.
That's the way it tends to be.
And do the same rules of judicial conduct apply?
Not necessarily. Again, very much depends on the arbitrator and what the parties have agreed to. When I do arbitrations, I tend to be, I would say, on the stricter side of the game. I tend to want the parties to have a feeling that they've had their matter arbitrated in a fashion that would be what they would expect in a courtroom.
Sure. We mentioned another form of alternative dispute resolution, and that's mediation. Tell us a little bit about that, Ron.
All right. Well, here's mediation, again, is in a lot of ways become more popular than arbitration. Mediation, the distinction between mediation and arbitration is where in arbitration, the arbitrator decides the case. What happens in mediation is a mediator attempts to bring the parties to a resolution on their own. In other words, the parties have to agree to it. And a skilled mediator uses tools we'll talk about in a little bit to try to get the parties to walk away satisfied that they've had their day in court, but that they were able to shape their own fate.
And so the mediator is really trying to bring a consensus rather than a ruling.
That's correct.
Okay.
That's absolutely correct.
So everybody leaves a little unhappy, and then you have success, right?
Oh, you've stolen one of my one of my best lines. That's where I was going to finish. It's absolutely true. I find the most satisfying mediations are those where everybody goes away with paying a little more than they wanted, and the other side taking a little less than they wanted.
What is a mediation binding? In other words, if a mediator can't bring the parties together, they can then still go to a court?
Absolutely. If it doesn't come to resolution, then in fact, you go right back to where you were. A couple of important things in that regard, because it makes people nervous. If the mediator has passed the statutory qualifications, then the mediation is absolutely confidential, and no party can use what went on in the mediation against another party in court. That sounds a little more important than it is, because, in fact, usually what you're discussing at a mediation has already been disclosed in the course of the litigation process.
At what point would someone go to mediation or arbitration? Would that be before they look at other more traditional ways of solving their problem?
Yeah, I think the answer to that's a little complicated. Typically, people go to mediation because what I spoke of earlier, the parties trying to resolve it themselves, has been unsuccessful. usually there's a blockage somewhere. So I think that pushes people towards the alternative of mediation. The other thing about mediation is it's, again, a more relaxed atmosphere and a less costly, significantly less costly way to resolve a case than a trial is.
When something goes to mediation, are there lawyers involved? Are they facilitators with the mediator?
Well, it's very, I wouldn't call them facilitators. I think when I'm doing mediations, I'm the one facilitator in the room. There's lots of ways, lots of things go to mediation. We'll talk mostly today about mediations involving personal injury cases because that's the simplest way. But there are also mediations in business disputes. There are multi-party mediations in real estate disputes. There are mediations.
I know divorce is a big thing now, right?
Took the words out of my mouth again.
Maybe I could do this job.
You could be doing this. In divorce, oftentimes, if the parties are agreeable and there isn't a whole lot in dispute, but typically parties can go to mediation just themselves. Mm-hmm. In fact, people do it if there aren't child custody aspects of the divorce, and it's just the question of material and money, then oftentimes the parties themselves save the cost of litigation, the cost of having lawyers by going to mediation. But the classic form of mediation today is really in the personal injury world.
Mm-hmm. Are there particular types of cases within that world that would be best suited for mediation?
I'm kind of biased, having been a mediator, and I think almost any case is suitable for mediation because the impediments to get to an agreement are typically personal. They're typically involve the people. An adjuster who, for example, who needs the protection of a mediation because so they can get the money from the supervisor to resolve a case, or in plaintiff's side, a client that needs the confrontation, see what the other side has to say in order to become more amenable to resolution. So, yes, there are situations, if there was a highly, involving highly scientific material or highly commercially specialized material, then, yeah, those cases probably lend themselves more to a mediation or even arbitration in front of a skilled arbitrator than to cast your fate to 12 good men and true.
One of the things I was wondering about, though, is that most personal injury cases, let's say it's a motor vehicle accident, okay? Isn't that really between the plaintiff and an insurance company to try to get the bills paid? Are insurance companies amenable to mediation?
Insurance companies are oftentimes the moving force behind mediations, and the reason is very simple. Their lawyers cost money.
Yeah.
And discovery costs money, and everything about the litigation experts cost money. Everything about the litigation process is expensive, and so for them, it's often wise for them to, and they often push for mediations as a simple, expedient way to bring resolution to the matter.
Are there cases that are better suited for mediation than arbitration, or vice versa? Are there certain types of cases that lend itself better to one or the other of those dispute resolution?
Yeah, I don't think so. I mean, I don't think there's any sort of type of case that makes mediation more reasonable than arbitration. Or
Is there for somebody, I'm just thinking personally, if I was in a situation where I thought I had a really good case, and my lawyer says, "You've got a really good case. We're going to get you this. We're going to get you this this money or this remuneration." In my mind, I would think, "Well, I want a jury to hear this. I know, or I feel like my story is. I'm sympathetic. I have a big family. I need to get money." Do people tend to get more money from a jury potentially, or from a judge, or from a mediation or arbitration, or does it not really matter?
I mean, one of the reasons people go to mediation is to, should I say this, to avoid the extremes that can occur in a litigation setting. You may have a very great case and have a very crummy jury. You may have a poor case and get lucky with a jury that wants to hand out money. But, the bottom line is, and one of the tools that a mediator uses when they get into the private sessions, which we talk about the mechanics, I'll talk about. But, one of the things that you do is you say, look, we're in this county, and if we were in Suffolk County, your case would be worth what you're looking at. But we haven't had a verdict like that in Hamden County in X number of years.
Right.
So, it's always hard to say. I mean, if your case is really super, take it to a jury probably.
And of course, most clients think their case is really super, right?
That's another reason to go to mediation.
And I had to think,
you get to see the other side and get to understand that maybe your situation is not exactly the way you see it.
Well, I have to think, as an attorney, one of your big challenges is to temper the enthusiasm of a potential client, or to be, get them to be realistic about what their expectations are.
Yeah, it's an outstanding point you make, and I think it's one of the most difficult issues to confront a trial lawyer, because you have to explain to clients the difference between being an advocate and being a counselor. And they're two different hats, and you've got to be very careful in your counseling role where your client loses faith in you in your advocacy role. So it's a very hard balance, for any trial lawyer. I think mediation, quite frankly, I hadn't really thought about this before, but mediation really allows you to comfortably wear both hats. There is an advocacy portion of the process. There's a counseling portion of the process.
I have to think, and this is just a little bit of an aside and a personal note, but I have to think, as a mediator, when you're successful, it's got to be very fulfilling to know you'll be able to bring these two parties together.
I'm going to be honest with you, it is. It's a lot more work than it looks. A good mediator makes it look easy. It's like anything else. A good center fielder makes it look, running down fly balls easy. But it takes a lot out of you in the process as a mediator. And I think the other thing is you have to be very careful of putting my lawyering role on, lawyer hat on now, is you really have to alert your client that the mediator is there to facilitate a result.
Yeah.
But his scorecard is different than your scorecard. Your scorecard is to get as much as you can in the situation you're in. And his scorecard is, I get the case resolved or not, and keep my reputation or my average up. So there's a little bit of a play there that you have to let your client know. Because mediators, quite frankly, if they're good enough and personable enough, the clients start to fall in love with them, and so you have to be a little cognizant of that.
Yeah. So let's talk a little bit about the process. How does a skilled mediator work, and what is the process like?
There are a number of different processes, but I'm going to talk mostly today about just the more typical situations, as we've been talking, the personal injury type mediation. There are a couple kinds of mediations. One is what they call an open mediation, in which the parties are in the room the entire time. It takes real ability to pull that off, because there's lots of ways that can go south on you. So the more typical mediation is a situation in which the mediator will have all the parties in the room to begin with and have an open session, spend a few minutes explaining how the process is going to work, why they have to commit to it, what they can expect out of it. And then what happens is one of the most crucial elements in my mind is the mediator will ask each side to make a presentation of their case. Give it your best shot, and that is important for two reasons. The first reason is the individuals feel like they've had their day in court. The plaintiff feels like my story's been told, and presumably it'll be told effectively by their attorney. As important and often overlooked is you have to sit and face what the other side is going to say and what the other side is going to, what's going to sound like in a courtroom. So you have to, you get to tell your story, but you also get confronted with the other guy's story. And one of the things I made that just sound like it's the first step in the process, but typically what a mediator will do will ask in advance of the mediation for the parties to submit their side of the story, so to speak. And the advantage of that is that it gives the mediator a heads up. It gives the mediator a chance to, when I get something like that, I sit back the night before and say, I kind of outline a plan of how I might approach it.
It gives you an idea, a roadmap of what questions to ask and that sort of thing.
Exactly.
Sure.
And what points to emphasize in the second part of the process. So that's really the first part of the process. Then typically what will happen, not always, but typically what will happen is the mediator will then break up into private sessions where the litigants go into separate rooms. And you begin what I call the risk assessment portion of the process. In other words, you talk to everybody about what the risks are of going forward, what the risks are of overplaying your hand, what you're going to be confronted with in the courtroom, and how you're going to deal with that. Occasionally, not always, I'll add another step, explain to the clients what I'm going to do, but then I'd ask the lawyers to stay in the room, the litigants to go to their respective corners, and ask the...
You like the sports metaphors, huh?
I do. I grew up with them. And I asked the lawyers, hey, what am I missing here?
Right.
Is there something here? And it might be, it's a home office case, and there's a guy in the home office, he gets up out of bed the wrong way every morning. So we got to work this with them, and that's what's been blocking this process. So, those kinds of things.
So the lawyers are the ones that are actually speaking in front of the mediator, or the mediator would then also ask potentially the litigants?
My typical practice is, and I think it's typical for most mediators, is after the lawyers have had their say on behalf of the litigants, I'll ask the litigants if they have anything they want to add or say, or do we miss something? So they can participate, and I like them to.
Mm-hmm. Or especially also if you need some clarification about maybe what their motivation was or what they were thinking at the time and that kind of stuff.
No, I may ask them questions that I think are important for everybody in the room to hear before we go our separate corners.
And then do you try to get to a resolution then and there, or do you go back and think about this and present a potential result? How does that work?
Typically what happens is this. In classic format, you'll ask what the plaintiff's demand is, current demand, and ask the insurer, the surer's representative, the defendant, what the offer is, and Oftentimes pretty far apart. I typically also advise my own clients when I'm there as a lawyer, but also advise the litigants when I'm a mediator, is these things always start like a minuet. It's going to take us a while to get rocking and rolling. and it's a lot of, I call it, again, the sports metaphor, shadowboxing going on in the early stages. And so it's really incumbent upon the mediator to kind of keep the people from walking out until you can get the process. Then once the process gets going, it's almost, it becomes sort of like any negotiation. I might say, or the mediator might say to the plaintiff, look, you're way out of line here. You really want to get this case resolved, you gotta come down here. And
this is that based on experience and what you've seen in other cases of this type? Is it based on, and I'm sure the answer is yes, all the above. Is it based on the particulars of this case and what is a normal range? Do you, as a mediator, take into account of what you think a jury would come back with or what you think a judge would come back with? How is that based?
The answer to that is you're correct. The answer to that is all of the above. But there's also, remember what I said to you a few minutes ago. My score, if I'm the mediator, I may think the plaintiffs undervalued this case, or I may think the insurers overvalued this case. It's irrelevant to me. My job is to get people to go, and get them to walk out of the room either slightly happy or slightly unhappy. But you're correct. I mean, you take all these things about what the common experiences, what these cases typically go for, and you try to. But I don't necessarily try to, and I don't think a mediator really tries to work to what they think the case is. It's more working with the parties to get them to where they're happy or where they're content with the resolution.
Get to yes. Yeah.
Yes.
So you've heard the case as a mediator or as an attorney. You've presented your case. Then what happens when everything has been presented to the mediator? Is there a back and forth at that point, or do you sort of go back? No,
usually there's a back and forth. Usually what happens is I'll talk to one of the sets of the parties, and typically I try not to make anybody feel bad because they're first. But typically, if I think, for example, that the defendant, the insurance company's undervalued this thing dramatically, I say, you want to get this case resolved. You got to make a step here. You got to make an offer, not anywhere near the end, but make an offer that shows I'm serious. I came to play.
A good faith effort.
I came to play.
Right.
And then you go back and say, hey, to the plaintiff, the injured party, hey, I know it's not anywhere near what you want, but it's a start. And, and you've got to come down a level with that same message that, I'm going to fight for my last dollar, but I did come to play. I did come to participate.
Now, are each of these parties in separate rooms at the time when you're having these conversations?
Yes, they separate.
So you're getting your steps in between the two rooms.
It's a back and forth. And sometimes, I don't want to call it easy, but sometimes the parties are more receptive than other times. Other times, it's they want to kick me and I walk in the room.
Now, what's the time frame like? So you've gotten the back and forth. Do they then want to go home and think about it? Can usually get a resolution that day?
Yeah, again, I'll give you some examples. Based on not just my experience, but my experience with, the very good mediators when I'm handling a matter on behalf of a litigant. The time-wise, these things can run. They can run from anywhere half a day to all day. Sometimes they're 2-day mediations, although I always find that 2-day mediation a waste because the first, not that the mediation's a waste, but the first day, I can almost predict you're going to not make any progress at all. But let's say you get to a case, you get to the situation where, the parties are so close and nobody will move. There's a couple of techniques that you can use. I may let it simmer and say, thank you, I'm sorry, we couldn't get it done, but you're so close. And I'll call one side or the other the next day and say, geez, I couldn't sleep last night because I almost had this thing put together, and you let it slip away. Let's see if I can't get them to, with the light of morning, get to where they should be. The other technique I use, I've only been burned on it once. The other technique I use in those kinds of situations is a mediator's resolution. In other words, I'll say to the parties, let's just say, one party's at $400 and $400,000, and the other party's at $200,000. Actually, I got to be much closer than that. But what I'll do is say, even though I said at the outset I won't decide this case, let me tell you what I think it's worth. I'm going to give you the number, and what I'll ask you to do is get back to me in a week, and I'm just going to want a yes or a no from each of you. I'm not going to tell the other side that you said yes until I've heard yes from you, so that
you've got a buy-in from both parties.
Yes, I have to have buy-in from both, and if both sides say no, for example, the other side will not know that the other side said no, so that neither side has changed their negotiating posture or cheapened it because
they're willing to give more than.
I did have one occasion where a lawyer said yes. The other party had said yes. I said, we got 2 yeses, and the lawyer came back the next day and said, well, mine was really a no. And needless to say, I've never mediated another case for that
lawyer again.
Yeah.
No, it's got to be frustrating, and it has to be. I would just think that from somebody who is doing this, you've got to have so many different skill sets. I mean, it really has got to be about having the negotiating ability, but also having a lot of empathy and being able to really see both sides of something as a mediator. As an attorney, I would think representing a client, you look at things a little bit differently. And one of them would be to try to ascertain what the pitfalls of mediation are. And for the client and for the lawyer, can you talk a little bit about what are some of those pitfalls? Why would someone maybe not want to go to mediation, or what could be potentially a result that would not be positive for them?
Yeah, I think, one of the nice things about mediation is there aren't too many downsides, because you walk out of the room, if you're not successful, you're in no worse position than when you walked in, other than you spent the time and maybe your client's been disappointed. But, I think you have to be careful, again, as a lawyer, and I'm representing a plaintiff now. If I know from my experience that the other side is really simply going to mediation to find out what more they can find out about my case, or to see, or just to evaluate my client for future positioning, then I would tell my client, my experience here has been bad, and I don't think that we should do it. But other than that, I think the only real pitfall is the disappointment. But again, sometimes that's part of the educational process of a client.
Yeah. But again, if someone's not happy with the result, or you can't get to a yes in mediation, the client can take it further and go in a more traditional resolution
Absolutely.
path. Yeah.
There's no, nothing changes.
Have you found that often people are acting in bad faith in a mediation and trying to get information, or is that really not happen that much?
That doesn't happen much. I mean, I don't have the active statistics. I think they're less strong more recently for reasons I really can't explain than they have been. But 85% probably of these cases come to resolution. And again,
That's pretty high.
mostly it is very high,
Yeah.
and it's mostly because most people would like to get their case.
They want to get it
resolved.
done. Yeah, for sure.
And so again, not a lot of downside.
Well, this has been really interesting, and I know that a lot of people that are listening, I'm sure, are excited to know that maybe there are some additional ways to resolve their dispute without going to court. And you've given us some really great information here, Ron. Thank you very much.
More than welcome.
If somebody wants to get a hold of you, they can do so at psrblaw.com, or, of course, our phone number, 800-785-5399.